We are about to start. If you want to sign up to speak on a bill, the sign-up sheet is on the table. So let's, if you haven't done so, let's go ahead and sign up. All right, ladies and gentlemen, Resource Management Subcommittee. We have two simple little bills. I'm just kidding. My inbox says otherwise. Vance, would you mind opening us in a word of prayer this afternoon?
Be glad to. Thank you, Mr. Chairman. Lord, we do thank you for this day. We just ask that you always keep watch and help us to pay better attention to the plan that you have for us, Lord. You've got one. We just need to know and work toward that plan. We ask that you be with each member here, each person in the audience. Be with our spouses at home, our children, our grandchildren. Lead, guide, and direct us. In Jesus' name we pray. Amen.
Amen. Thank you. And just to clear up, before we get started, we do plan on having a meeting in the morning as well. We know that HB 748 has a lot of passion to it, and we're not on Zoom, so we want to make sure that we gave enough time for that. So with that being said, I would like to start off with House Bill 1479. Chairman Corbett, if you come and present that to us. Committee, just look in your folders. All that info should be there.
Thank you, Mr. Chairman, members of the committee. I bring before you today HB 1479, LC 510146. Is that what everybody has? I'll start with a little background on what we have now and what we want to do to bring a solution for the problem. The Georgia Board of Registration for Foresters currently resides within the Professional Licensing Division as part of the Georgia Secretary of State. The board serves as a professional licensing body for foresters. It is in charge with protecting the public health, safety, and welfare by regulating those who engage in the practice of professional forestry. The board has the authority to adopt rules, set standards for licensure, adopt mandatory standards of professional conduct, and investigate and discipline unauthorized, negligent, or incompetent practices. The authority is provided in OCGA 12-6-42. The board is comprised of 6 members, 5 professionals, and 1 consumer member who are selected and appointed by the governor. Currently, there are 912 active licensed foresters in the state. The issue that we're having, many foresters have expressed deep frustration with the lack of responsiveness, support, and communication from board staff. Further disappointment is felt by the low level of support provided by board staff in addressing and investigating complaints lodged to the board. Current board members who are professional foresters and employed in the private sector are becoming discouraged by the regular contact received from new applicants and licenses seeking service from the board staff. They are also concerned over the lack of urgency and responsiveness of the board staff in completing investigations in a timely manner. These issues are concerned as it clearly creates an issue for public welfare. At this time, I'd like to read a text that I got yesterday from a constituent of mine who is a registered forester and whose son is also now a registered forester. He said, just want to say thank you for the bill to move Georgia registration out from under the Secretary of State to the Georgia Forestry Commission. It's been a nightmare dealing with the SOS office. It took Kyle over a year to be registered after completing the requirements and after payment went through. Thanks for all that you do for forestry. So it's been a big concern, and I checked with another forester. Is this an issue been going on, pre-COVID? And he said, yes, this was pre-COVID as well. So it's something, COVID probably made it a lot worse, but it's been going on before then. So the solution that we propose to bring forward in this bill, we want to relocate the operation, function, revenue generated by the Georgia Board of Registrars for Forestry from the Georgia Secretary of State office to the Georgia Forestry Commission. The benefits of doing this. Georgia Forestry Commission is a state forestry agency with the mission of protecting and managing the state's forest resources. Moving the board is in alignment with the Georgia Forestry Commission's existing mission. Georgia Forestry Commission has a reputation of high customer service. Improving basic customer service functions such as application processing, scheduling of testing, communication, and responsiveness will be achieved. Georgia Forestry Commission's Law Enforcement Division is often requested by the Secretary of State's investigators to engage in investigation complaints due to the complexity of the issues involved with forestry and timber cases. GFC's Law Enforcement Division is responsible for investigating timber theft and arson cases in the state. Georgia is the #1 forestry state in the nation. Given such, the Georgia Board of Registration for Forestry should function at a level that honors the importance of forest industry within this state. At this time, I'd like to read a text from the commissioner, the director of the Forestry Commission, Tim Lowmore. All right. Said every day, Georgia Forestry Commission employees serve our state, its citizens, and its forestry community well. Based on our long history and experience in Georgia's forestry community, we have the knowledge and capacity to successfully implement HB 1479. Should the General Assembly pass the bill, while funding is not specifically addressed in the legislation, we understand that the House is working to include the necessary annual appropriation of $85,000. We appreciate the House recognizing the importance of providing the agency with resources needed to perform the services outlined. Thank you for your continued support of the Georgia Forestry Commission. And on the funding piece, I have been working with Penny Houston, and they have got money in the budget in the form of a grant. It's a $1 million grant that will be able to fund this for the first year. And then after that, the fees that the members pay will cover going forward after this first year. So the money will be in the budget to cover this. So let's talk about what the bill does. We'll walk through it real quick. It's, like you said, it's a simple bill. Section 1, basically, it's got a little bit of clean up language in here, but line 39, here's where we are moving the board from the Secretary of State's office and attaching it to the Georgia Forestry Commission in Section 1. Section 2, where basically the chairperson of the State Forestry Commission will serve as secretary for the board. Then Section 3 allows the board then to issue cease and desist orders against bad actors out there that are operating without a license or doing things that are unethical when it comes to forestry. And then it gives the ability for them to set the fine. It's got the limits in the rest of Section 3, and that's basically all the bill is doing. And I believe by moving the Board of Registration for Foresters from the Secretary of State's office to the Georgia Forestry Commission, it's definitely a better fit, and the public will be better served. So I would ask for your favorable consideration for HB 1479, and stand for questions if there are any.
Very good. Thank you, sir. We do have a question. 17, yes. Chairman Whitney.
Thank you, Mr. Chairman, for bringing this bill. Good bill. I'm certainly for it. I signed on to it, but I do have a question. How many registered foresters do we have in the state?
912 active registered
912.
foresters.
So how many, I'm just curious what kind of staff it will take to do this licensing going forward. Will the fees, I mean, you talked to that.
I talked with him, and he estimated $85,000 to do that. And the fees, if you're looking at 912, if $100 a year will do, will more than cover that, $91,000 with just $100 a year for their license every year.
Okay,
So,
I just wanted to
and they have not
be
updated
clear.
that fee structure in quite a few years. I understand that's in the works of being done, and those fees will cover that $85,000 that the director said it would cost to administer this program.
Thank you.
Thank you. And let's see if I can run my own board here. Representative Francis Williams.
Thank you. So, yes, thanks for bringing this bill. Do you have any idea about how many people are actually waiting for their completion of their their registration or licensure?
I don't have that number. I just was, when my constituent just texted me this yesterday, when he seen this bill out there to thank me and let me know what his personal experience that his son, had when he went through and did all the paperwork, all the requirements, paid the fees, and the check got cashed, but then it was a year later before he actually got his certification.
Yes, I understand that there are waiting lists for
Yeah.
people who have applied to other licensing boards for licensure. So I just, sorry to hear about the waiting period. But anyway, thank you for bringing this bill.
Thank you for the question.
Thank you. And now Representative Campbell.
At the proper time, I'd like to make a motion to pass.
Thank you, sir. Do we have other questions? I actually have a question. On line 21, we have added for terms of 5 years. Can you speak to that a little bit? What do we do now? And tell me why we put this
Well,
in here.
I think on line 21, we did that there. If you look further down line 23, where it started in 1985, when this was its initial term, was for 5 years, appointed by the governor. That's just cleaning that up and stating it in line 21.
Perfect. Thank you. All right. Any other questions? We have a couple of folks who wish to speak on the bill. Mr. Brian Stone. Where are we at?
Chairman Barr and committee members, my name is Brian Stone. I'm the current active chairperson for the Georgia Board of Registration for Foresters. Chairman Corbett, I think you read my notes because you covered almost everything that I wanted to bring forward today. So I'm going to be real short here, and I'll be open to any questions that you may have. The idea here is that we feel like the Georgia Forestry Commission shares in a lot of synergies with the Board of Foresters. Obviously, that's the state forestry agency. And, our missions are very similar in that we both are in the line of protecting public in different methods. A couple of high-level synergies I want to hit real quick is the GFC has a vested interest in the forest industry, in which we think that goes a long way. Having a vested interest in seeing these licensees or applicants for licensure get through the process in a timely manner is a positive. They are subject matter experts, so when we do have complaints or issues that are filed with the board, they will have the expertise on staff to be able to craft questions to go forward with investigations. And then I think you also brought up the fact that they do have investigators on staff, and it's our understanding that we will be able to utilize those investigators to complete that without having to go through the state investigations where they're sharing with elections and 40-plus other boards and whatnot. We'll be able to move a lot faster. So those are my high-level points that I wanted to share today. And I thank Chairman Corbett for bringing this legislation forward or this bill forward. And I would just open it up now if y'all have any particular questions of me as the chairman.
Members of the committee, question? If y'all don't, I actually do have one.
Yes, sir.
In section 3, is this a new authority granted for the fine and the cease and desist, or is that currently existing? Can you walk that through?
So Section 3, my understanding there is we had an issue in that our board was initially set forward in 1951, and it was under Section 12 of the code. And we have been advised by our Attorney General's support that we needed to get that cleaned up to Section 43, or to 43, because that affects our ability to issue and uphold cease and desist, and also our ability to fine individuals through the cease and desist process. So that would be new here, but it is a cleanup to be in line with all other boards from my understanding.
Okay. Can I further on that? Is there are there bad actors currently right now that this would help with? Talk us through that.
Yes. So I've been on the board approximately 6-7 years now, and in that time period, we usually have around 3 or 4 complaints a year. A lot of those are unlicensed practice. They're individuals that don't have license and they're out upholding themselves as a licensed professional forester. But then occasionally we will have what I call the really bad actors, the individuals that are out there taking advantage of the public, of individuals that are not knowledgeable in our business. And so that's typically our caseload there. probably around 3 unlicensed practice and 1 really bad actor that needs to be handled.
Very good. Representative Buckner.
Thank you, Mr. Chairman. I don't mean to put you on the spot. I have no problem with this. I just have a question. We have an agency that's supposed to be responsible for this that obviously is having some difficulties carrying it out. I don't want us to move it and have similar problems without knowing that we're moving it to a place where all that can be fixed and we can operate like we're supposed to. So my question is, you're obviously aware of the problems that have been occurring. How, when we move it, will those be addressed so that they won't be an issue in the future?
Okay, well, that's a great question. And actually, some of those will fall on Director Lowermore at the Georgia Forestry Commission to manage this as part of his administrative duties for the board. I would say that I have the utmost confidence in the Georgia Forestry Commission and their employees. Again, I'll restate what I said earlier, that they have a vested interest in seeing this is carried out well. So that is where I have my confidence that this will be better. Our numbers are very small. 900 and Chairman Corbett, what was the number again? 917? 912 active right now. We have around 45 applications a year that come through. I think there was an earlier question about applications. Those applications vary by type. Some of those are new individuals seeking examination. Some of those are individuals seeking licensure through reciprocity from another state. And some of those folks have just lapsed and they're looking to get their license back active. So it's not a real heavy lift for the commission, and in my conversations with Director Lowermore, he's very comfortable with what we're asking for here.
Very good. I don't see any more questions, and so we have one more presenter on the bill, Georgia Forestry Association, Andres Villegas.
Thank you, Chairman Barr. It's a pleasure to be with everyone this afternoon, and it's good to see everyone. As I stated, my name is Andres Villegas. I'm the President and CEO of the Georgia Forestry Association. We represent the entire forestry supply chain, from nurseries and landowners all the way to our loggers, harvesters, truck drivers, and manufacturers. At the core of Georgia's $39 billion forest products industry is the landowner. The landowner that makes that decision to grow a tree. And what makes forestry different than every other agricultural crop is that we have to wait about 25 to 30 years, sometimes longer than that, to really realize the full value of that. Oftentimes, in that time frame from when the trees are planted to when they're harvested, in that final harvest, and then reforested, the ownership of that asset can change. It can pass from maybe a husband to a wife, who maybe didn't have a full knowledge of all those things were happening with that asset when those decisions were made, and how you harvest and how you manage that asset. And in that process, or children or whoever it is that inherits that has to depend on a forester for those decisions that they need to make to be able to realize how to monetize that asset, how to be able to reforest, all those difficult decisions. And that is based on trust. Like so many things in our economy, it's based on trust. And when we have bad actors out there that are taking advantage of folks who are in vulnerable positions, and this can happen. It doesn't happen every day, but it can happen. We have to send a very clear signal that we will not stand for it as a state, and we won't stand for it as a community and as an industry. And so for us, as the Georgia Forestry Association, on February 8th, our board endorsed this action, this bill, if it were to come through. And so we're very pleased to see it come through. But we see this as a very simple consumer protection action for one of the greatest natural resources that we have in the state of Georgia. The second component is, as you heard already, this is a great fit. The Secretary of State's office is already coming to the commission asking them to do most of the work. The commission is limited and they can't close the deal. There's things they can't do by law, and that's why we're asking for this action. Let's give the folks who are best at this work, who are already doing a good part of it already, and who have the knowledge base and who have the offices scattered throughout the entire state, to be able to engage and know the communities. They know the landowners, they know the loggers, they know the foresters. Give them the opportunity to really leverage the assets that we already have as a state of Georgia. And so for us, we are very favorable for this piece of legislation, and we ask for your favorable consideration, and happy to answer any questions that you may have.
Any questions? Very good. Thank you, sir.
Thank you, Chairman.
All right, we have a motion on the table by Representative Campbell, do pass on HB 1479. Is there a second? We have a second. All in favor? Aye. Opposed? Very good. Thank you so much. All right. Let's move over to House Bill 748. And we have a substitute to that bill in front of you. And we are going to have a hearing on that bill today. So, gentlemen.
Thank you, Mr. Chairman.
Welcome
And members, thank you all. I want to tell you all, first of all, thank you for allowing us some time to get back with you. That has been in the interest of making sure we get this right. We have worked diligently to take input from numerous interested parties to try to make this better. I have Representative Deloach with me today, my friend, and someone like myself has spent his lifetime on the coast and is well aware of some of these challenges that we're trying to address today, and I appreciate him being with me. He's one of my top co-sponsor here on this measure, and Representing McIntosh and other counties down there understands well what we're trying to accomplish. Let me begin, if I could, just to remind everybody, because it has been a minute as we've tried to get this right, to make sure that everybody understands exactly what we're trying to do here and what we're not trying to do. And so let me begin, and then I'll go through the bill, Mr. Chairman, if you don't mind. But again, what we're trying to do here is make sure that that we have a fair and a fair process for individuals to make a determination on whether or not they have a grant that goes back to a King's grant or to a state grant. It turns out that many of these grants, more than half of them, are state grants by governors and previous legislatures way back in the day. There were some questions at the last meeting about how much of this land is out there. We understand from DNR, who has been extremely helpful in this matter, and I know they're going to testify today, and they've been very helpful to me in trying to just answer questions. But there's about a little less than 36,000 acres on the Georgia coast that are likely encumbered that could be considered in this measure. Much of that land may be altered by dredging, islands that have been piled with dredge material, et cetera. So that may not quite be an exact number, but there's a lot of marsh on this coast that has been altered by man. Most of it way back in early colonial era, as we discussed before, so I won't get back into that. So whether we like it or not, that's not the question today. There is a great deal of land on the Georgia coast that is owned by private individuals. That is not, we're not changing that today, and this bill doesn't seek to do anything to alter how someone has to prove that. You still have to prove whether or not you own something. Nothing changes that. However, what we are trying to do is make sure that there's a fair process to individuals to do so. Okay, so having said that, let me first say, as I speak to some of the changes, let me say this. And everybody, do you want to go first, or do you want me to come back to you? We'll come back to Representative Deloach. So I want to first make it clear that one of the first things we did, we went ahead and moved this from Title 12 to Title 23. And I hope that you'll see that in the new sub. And by the way, Mr. Chairman, we're looking at LC 44202.8S. Make sure everyone has that. 44202.8S. All right, that is the most recent sub. We've had several iterations. We've tried to perfect this. So we moved this title to the code where we deal with private title, which seemed to make more sense. And so we've done that, and I want you to recognize that as a major change. As you will on line 4 and 5, you will see that we've now made the location for presenting these abstracts of title no longer to the Attorney General, but to the State Properties Commission. Well, why have we done that? We've done that because as we dug in, we determined, with Legislative Counsel's help, and I want to thank Stuart back there and also Paul Higbee, who have been enormously helpful to me in this regard. We discovered that we may have a constitutional issue where we have the folks that are supposed to be defending this, judging it as well. So we had a conundrum there with serving the Attorney General, and so now we have State Properties Commission, where this abstract will be presented, and then the Attorney General, of course, will defend them as they defend the state and not individuals in this state. So we think we made that much better, and we did it for that reason. If you'll follow with me, I'm going to point to some major changes, but first I want to point to the findings, because I think on page 2, if you look at the findings, you'll understand what we're trying to do. Okay, very clear. So what are the findings? Number 1, there are significant portions of the coastal marshlands of Georgia that have already been altered. They were altered before the enactment of the Coastal Marshlands Protection Act in 1970. That is a fact. Number 2, the restoration of those marshlands is a good thing, okay? And if you'll note here, it says that the restoration of coastal marshlands from alteration caused by such activities will enhance the productivity of the nursery which the coastal marshlands provide for shellfish and other forms of marine lice, et cetera, et cetera. So it's a good thing when we restore the marsh to its native state. And I haven't met any group to date that disagrees with that. And there may be at a certain occasion or certain location, but by and large, generally, restoring these marshlands to their native state is a good thing. Number 3, third finding here is that, again, as I said earlier, certain portions of our coastal marshlands are owned by private parties that can trace their title to valid Crown grants or state grants, and that preservation or restoration of such coastal marshlands may not occur unless undertaken by the owner or owners of said coastal marshlands. That's a very important finding as you try to contemplate what we're trying to do here. Number 4, and this is really important, the fourth finding, establishing a framework to facilitate the identification and preservation or restoration of privately owned coastal marshlands is a proper function of the state of Georgia. Okay, very important. Ultimately, that's what we're trying to do here. So those are 4 fundamentals, facts that I want everyone to recognize. And then on line 35, you see we go into a couple of purposes of this measure. Purpose number 1, if you'll see there on line 38, so that there shall be no occasion for such land in this state to be unmarketable because of any uncertainty as to the owner of every interest therein. On line 40, you'll see this part is intended to encourage the restoration of altered coastal marshlands to their natural state and to encourage the protection of coastal marshlands as a complete ecological system vital to this state. All right. Having said that then, Mr. Chairman, we then go into kind of the meat of the bill. We define conservation purposes, okay? And I think we went through that pretty well last time. But we define conservation purposes. We added, there is an add on line 64. We added the word adverse possession. When we talk about a definition of tracing title, we add that. And then on the next page, we have a major change on line 80. As we discussed here last time, we pushed that back to 6 months, okay? And we have on line 82 and then on line 84, you'll see the 2 route, the certification that the petitioner has traced the title to a grant, or B, failure to issue a certification within 180 days. We have the 2 routes there. All of that is consistent with what we had before. I mentioned earlier the AG office would represent the State Properties Commission. I'm trying to make sure I catch my changes. And then we can come back and answer questions. We've already, again, in the interest of time, we have discussed many of these issues about Superior Court, special masters, and here's a big one I want to mention from our last conversation. On line 126, I want to make it very clear that any coastal marshlands and uplands, so that was a major change contained herein, which are subject to a decree as provided for in this part, shall be restricted to utilization for conservation purposes. So every part of this property, if one were to use this process, would be under a conservation easement to include the uplands. There are new sections between line 129 and 141, which is some language I just discussed with DNR. We're going to come back, I think, and speak to them in a moment. But actually, A and B were already in. The new section is on line 138. The C provision is new. And then I think everything else on this page is as it was. You see the decree there would go in the title, making it clear that everything is restricted to use for conservation purposes. I do want to add, because we have Representative Buckner here, that we added a very important piece that she mentioned on line 173 to 175. We mentioned the carbon sequestration registry, which I thought was a good idea as well. So those were the changes in the bill from the last time, Mr. Chairman. I had several individuals, experts, that were to be speaking today to us by Zoom. I learned this morning we don't have access to Zoom today in this room, and I was disappointed to hear that. So because I want to make sure that if there's any questions, and those individuals can be available for tomorrow's meeting and any other date. But I have learned a great deal. I began with very superficial understanding of this issue, and so I have been speaking with attorneys who are experts in this regard, land resource consultants, a gentleman by the name of Ferris Cadle, who is remarkably knowledgeable, that has been a tremendous help to me, who has spent 30-something years of his career tracing king and state grants. And I think I've learned more from him than anyone else, without question. And so what I think I've learned, and what I think most of our coastal delegation know, is this: the current process is cumbersome, and it seems to be quite unfair to citizens. It is often not consistent, and in that we have two paths. One being a path of going to trial, which always exists for an individual. There's this path that we have as an alternative to going to a trial. Currently, in the way it operates, is quite frankly no more beneficial or less expensive than going to trial. And so we have people that are they believe have done everything they need to do to trace title and to pay for that very expensive process back to a grant. And it seems like it's constantly pushed back. It's constantly delayed. And it just doesn't seem to be a very citizen-friendly process. I want to make it very clear that, because I know some of y'all have gotten emails, and you've told me what you're hearing in those emails. I want to make it very clear. Everything in this bill is encumbered by a conservation easement. No one currently can develop the marsh. All of the marsh, whether it's owned privately or not, is subject to, and this bill states that, is subject to the Marsh Protection Act of 1970. No one is trying to develop the marsh. No one. That is an absurd suggestion, and it is patently false. None of us on the coast would ever support such a thing. There are altered marshes that could be restored to the benefit of our coastal communities. And the question is, if an individual owns them, we need to give them, shouldn't they have the opportunity to prove it or not? The State Properties Commission can say, nope, you haven't proved it. That's fine. Then they can go to trial. But to require citizens to languish for years on end, which are the stories that I've heard again and again and again, is simply not good government. And that's the issue we're trying to address today, Mr. Chairman. Mr. Chairman, I'm going to have my colleague here maybe say a few words as well.
Thank you, Mr. Chairman. I want to talk very briefly about what we're really trying to do here. And I want to use an example let's say, for instance, I own 25 acres of what used to be marshland, but many years ago, before it was protected, that marsh was destroyed by commercial activity. So it is not now a functioning marshland. It's just sitting there. I think I own it. I'd like to sell it for for mitigation, and it would be restored to a functioning marshland. But currently, I don't know how long it's going to take me to prove that ownership, and I don't have any idea how much money that's going to cost me. So the purpose of this legislation is simply to give me a track to run on, tell me exactly what I'm going to have to do to prove that ownership. And then I can make a decision. If I'm convinced that I can prove I own it, then I'll go through that process. The only thing that can happen if I prove I own it is it either stays exactly like it is, or it gets sold for mitigation and it gets restored. Now, as far as the marsh around it in the restoration process, that marsh is very carefully protected, and I can assure you, if anybody's going in trying to restore that neighboring marsh, they're going to have an incredibly careful plan to make sure they don't damage any of the marshland around it. I know how hard Representative Petrie has worked to make sure he accommodated everybody's concerns. And I really think, with perhaps one small change that the department talked about before the meeting in the morning, we will have ensured that nothing bad can happen to a piece of functioning marsh because of this bill. The only thing that can happen is that non-functioning, damaged marshland can be restored back to a productive marsh.
Thank you, Representative Deloach. And I would say, just to Representative Deloach's point, I mean, we're going to encumber a lot of uplands if an individual chooses to go this path, whether it's hammocks or otherwise, that would not necessarily be in conservation easements, but would be if someone chooses this route. But again, we just have to keep saying it because we know how it works up here. You know, you get robo emails from people that don't know a thing about they haven't read the bill. You get the robo emails, and next thing you know, you're trying to destroy the marsh. There's nothing could actually be further from the truth in this measure. We're trying to encumber it for conservation permanently and forever. It cannot be developed anyway, and as it should be. But any questions, Mr. Chairman? We're glad to answer to the best of our ability, and there's others here that I'm sure want to speak to this measure.
Absolutely. Committee, we have had a chance now to look at the substitute. I expect there's some questions out there. Who was 14? I apologize. Yes, ma'am. Please, Representative, go ahead.
Okay, so on page 4, the section A, one thing that hasn't changed, you have given the authority, the State Properties Commission, 180 days to provide the petitioner with written certification. But the thing you haven't changed is that, and you say certification shall be binding upon the state. Failure of the State Properties Commission to issue a certification within the 180-day period shall be deemed an admission that the petitioner has traced the title to a grant. So you have left in place the fact that if the government entity fails to act within a certain period of time, it automatically admits the petitioner's has traced the title to a grant.
Not quite, and I may get Mr. Stuart Morelli back there, our legislative counsel, to help me on this because we've had some discussion about that. That's actually not correct. So remember, all of this section is built around the petitioner has got to present an abstract of title. They have all This whole process begins after they've done, I don't know how long it takes, however long it takes, depending on the acres involved. They've got to present proof that they have clear title. And yes, in A, we're saying that we expect to get an answer, unlike what happens today. But to this question that has been discussed with Legislative Council, that doesn't mean in any way that if just arbitrarily someone with no evidence or proof that they have clear title is going to wind up getting this piece of land. And by the way, that would be no different than what exists today, I guess.
But it says
With a special
on line,
master or something.
It says on line 76, a petitioner may present to the state. It doesn't say
line
must.
56?
76.
76.
Prior to filing a proceeding, a petitioner may present to the state an abstract of title.
Yeah, I spoke to Mrs. Rogers this morning about that. That was the first that came to my attention. And if that needs to be, I would ask again Legislative Council. I've had to lean on them greatly. I'm not an attorney. But if currently the situation that we have with the Attorney General's office, my understanding is that's the language that's used today with the current process, but I'd have to defer to Legislative Council on that.
Follow-up question, please?
We are running a little bit short on time. We are going to have another meeting in the morning, so
Okay.
are there other questions?
I'm glad to get any advice for changes, Chairman.
Very good.
I welcome them.
Yes. We'll come back if we have time. Chairman Smith.
Thank you, Mr. Chairman. Representative over here. So one of the robo messages out there that this whole process is just for one individual. Could you expound on that?
Nonsense. Yeah, I could if Mr. Cadle were here as had been desired, or one of two different resource consultants that most of us learn of issues from our constituents. And then what we do is we begin to discover and to dig and to learn. And what I learned from Mr. Ferris Cadle in particular, but also from several others to include Alton Brown, who's probably the most knowledgeable individual in this field that I know and trust in Savannah, is this is a chronic and recurring problem. This is a chronic problem. So that is nonsensical. Again, as often is the case.
Okay. Representative Buckner.
Following up with one of the things that I've heard in the many different phone calls and emails that I've received is that generally the process is longer when there's an issue or a problem that has to be investigated. So that it's not that the process is not necessarily flawed or not working, but that they run into issues with either not the potential landowner can't prove what he's saying to the Attorney General's office satisfaction, or it doesn't match up with records. So I don't know how to deal with that in my mind, that if we've got a process and it's long sometimes, but it's not other times, is it because it's long those times because they don't have what they need? Or that there's a problem of some sort?
Yeah, I had that question myself early on as I tried to discuss it with the AG's office and others. And here's what we've been, particularly again, I keep referring back to this Mr. Cadle. So that's not quite the case. I'm sure that may have been the case. I'm sure there are occasions where individuals can't produce. My comment there would be then just don't rule in their favor, but make a decision, okay? So make a decision one way or the other. But what we have heard are just numerous examples where nothing is questioned, and then all of a sudden there's new questions that come up. And remember, again, going back to the beginning, the petitioner has to do all of this research in advance. All of that has to be done in advance. The AG's office in the current process is just reviewing that which has already been done. Okay, and so if you can't prove you have title to a piece of land like any other process where we might deal with this issue, it's not yours. It's pretty simple. There certainly are some special considerations, being that during the war between the states, I mean, you know, courthouses were burned to the ground, and you know, I get it. We're dealing with documents that are very old, so I get that. I think there's some of that, but I think if somebody's just intractable and not providing answers, we expect that's going to be delayed. That's really not the issue. I'll be honest with you. I had a conversation with the AG's office, and not with the Attorney General, but some of his staff, who have been extremely helpful, by the way, and have you know, have said, you know, we're watching the process, and we'll, you know, we do what the legislature provides for. But I will tell you, there is a recognition that there have been many occasions historically where these things are slow rolled. There's a recognition that that has occurred historically. And that's not, and that it goes back to what Representative Deloach was saying. There's not been a really defined process with a timeline for how they do this. And that's what we need here. But I'm glad, please, Representative, ask all you can. It's helpful to me.
Well, I'm not a lawyer, but when I look at lines 135, 136, and 137, and it says that the claim of the title under the claim of the right, and that the use was public, continuous, exclusive, uninterrupted, peaceable, and not merely passive, and that the title was acquired by such person. And maybe Legislative Council can tell us, are those the usual conditions and terms for transfer of land that are required? And are those defined in a way that keeps this process flowing, or are they an encumbrance to the process? Do you see what I'm getting at? That's a lot of things to check off to make the transfer happen. And if they're not defined, you know, we have trouble with words not being defined in some of our laws that cause hiccups. And
Gotcha.
That part right there, I don't understand. I don't see how that makes it faster. I don't see how that could make it faster. And I also wondered about the state properties being involved, because most of the stuff that they deal with when it is state property, it has to come before the General Assembly in order to get approval for it to leave state hands and go to private hands, and right. I don't see that as a part of the process in here, and would that be required? And I won't ask any more because I know you said it.
Okay.
Understood.
We are at about 8 minutes to go. We have 3 folks that have signed up to speak. Any of our presenters that have signed up to speak have come a long distance and cannot be here in the morning. Ms. Megan?
Thank you. I actually got up at 2 o'clock this morning, and I have to turn around and drive back to the coast. So I appreciate you taking my comment.
Yes,
I also appreciate Representative Petrie being willing to work through this process, because it's a complicated bill. It's a complicated process that not many people know much about, including myself. And just like him, I feel like I've learned a lot since this bill was introduced. I just have a few things to say, and he and I spoke already this morning. I just feel like I need to share my concerns with y'all too. You got a letter from me and some of my colleagues last week about the previous version of this bill. And I wanted, after that, he sent me the substitute language. And so I've spent the weekend thinking about it and talking to people about it. And, you know, I understand what we're trying to do here, and I appreciate it. And I think nobody wants to stand in the way of somebody having a right to something that they have a right to. But I just want to make sure that we're not creating some undesirable, unintended consequences with the way that the bill is worded. And so it's super important, especially when we're dealing with a resource like the salt marsh, that we make sure that it's right. And as with everything, the devil is in the details. So let's walk through a few things that I'm a little bit concerned about. And some of them have been mentioned, but some of them have not. Okay, so on line 75, section 23-3-78, I think Representative Williams mentioned this. So this is the section that starts to establish the process. And the word may is in that first line. And so in my reading of this, the word may indicates that this portion of the process is optional. It's not something that's required. The individual may choose to do this, or he or she may not. And then that kicks us over to, if this is the start of the process, if you go to line 128, which is in section 23-3-83, this outlines the three, I call them pathways. If indeed the first section of this is optional, then these pathways can be interpreted to be a bypass for someone who actually lacks a grant. That's my reading of this bill. And so, if you go to Section A, says that the mere existence of a grant, so to me that's a piece of paper that says that you have a grant, whether or not you've gotten that grant certified or whether or not you've proven that you've met all the conditions, creates a rebuttable presumption that the state has divested itself of any interest in the property to the low water mark. This changes the status quo, in my interpretation, in favor of a private individual and removes the burden of proof to ensure any compliance with a grant. This Section B says if the marsh has been manipulated, and it doesn't say when the marsh was manipulated or to what extent it was manipulated. It could have been manipulated in the last year with a minor manipulation or minor change. It shall be presumed that the manipulation occurred prior to the passage of the Coastal Marshlands Protection Act of 1970 by someone in the chain of title. And that existence of the altered marsh creates the case for an individual to take possession of the marsh away from the state, again, in my interpretation, even without a valid Crown grant. And then finally, Section C states that these two conditions, plus a determination of good record of the title for only 40 years, and we're talking about a King's grant that could be, or a presumed or claimed King's grant that could be 250 years old, but we're only going to go back 40 years, creates the presumption that the title has indeed been traced back to a valid grant. So these three conditions create a pathway that is, in my opinion, appears to be a bypass of having a Crown grant. And I understand from Mr. Petrie that that's not what he intended to do. So let's make sure that that's not what we did by accident. Okay, I'm almost done. Sorry, I have lots of notes. And then, the other important point that I want to make is that there is an additional giveaway, I think, in this bill, and I think it's unintended. Even if the may that I mentioned before were a shall, Section 23-3-83, Section A, conveys ownership of the marsh to the low water mark. And I don't know if y'all read our letter last week, but essentially there's a big group of us that are concerned that in our letter we point out that under longstanding law, unless a grant has expressly conveyed title to the marsh bed, Crown or state grant owners do not own the marsh bed below the high water mark. So this additional language of low water mark, in our opinion, creates an unintended potential giveaway that we are extremely concerned about. So I hope that you will hold on to this bill so that it can be studied further and the language could be further developed, because I understand that's an important problem that we have, but it's also an important resource that we have that we should not in an unintended way impair. Thank you for your time.
Thank you so very much. Unfortunately, we are out of time for today, but that is why we have another meeting for tomorrow, and you can answer some of those questions. And I think this is a great, robust conversation we're having, and I appreciate all the members' attention to this important matter. Thank you, sir. We are adjourned.